Earlier this week, I spoke about the history of the blue slip courtesy. I hope my colleagues will read that history as well. And I explained in that speech earlier this week, in my nearly 4 decades in the Senate, I regularly returned my blue slip, even when I would have preferred that the President had nominated someone else. Today, I'm announcing that the Judiciary Committee will hold a hearing for 2 Circuit Court nominees, each of whom has 1 home state senator who has not returned a blue slip containing a positive endorsement. The hearing for Justice David Stras, nominee for the 8th Circuit, and Kyle Duncan, nominee to the 5th Circuit, will take place on November 29. Both of these nominees appear to be very well qualified, and they deserve the Judiciary Committee's further consideration. I'd therefore like to offer an explanation as to why I'm choosing to proceed on these nominations and allow the hearing despite the lack of 2 positive blue slips. As I explained earlier this week, the blue slip courtesy is just that, a courtesy. For 100 years, the Judiciary Committee chairmen have asked for the views of home state senators on judicial nominees via the blue slip process. The blue slip is meant to solicit insights into nominees and ensure that the White House is adequately consulting with home state senators as the advised part of the advise and consent would imply. Let me be very clear. I will maintain the blue slip courtesy, but some of my Democratic colleagues and left-wing outside groups mistakenly assert that the blue slip affords a home state senator veto power over a nominee. That is not true. Only 2 out of 18 of previous chairmen of this committee in the last 100 years allowed a single senator to wield veto power over a nominee. Senator Joe Biden, when he was Judiciary Committee chairman, articulated what I consider a sensible policy with regard to the blue slip. He said that a negative blue slip will be a significant factor. A significant factor is his words, for the committee to weigh, but that, and I quote further, it will not preclude consideration of a nominee, end of quote, unless the administration failed to consult with the senator. I intend to follow this practice for negative and unreturned blue slips. This practice is consistent with the vast majority of blue slips history. I'll add that I'm less likely to proceed on a district court nominee who does not have 2 positive blue slips from home state senators. But circuit courts, as we know, cover multiple states. There's less reason to defer to the views of a single state senator for such nominees when that nominee is going to serve several states in a circuit. It's important to remember that the judicial confirmation process has changed over the last several years. Previously, when home state senators didn't return a positive blue slip, their colleagues often defeated that very same nomination on the floor, but not in committee. When President Bush nominated Carolyn Kuhl to the 9th Circuit, her home state senators didn't return positive blue slips. Chairman Hatch, nevertheless, held a hearing and a vote for that nominee. Her home state senators, however, convinced their colleagues to filibuster the nominee on the Senate floor. Carolyn Kuhl was never confirmed. But a few years ago, as we know, I think it was 2013, Democrats abolished the filibuster for nominees to the lower courts. They argued that a minority of senators should not be allowed to block nominees who had majority support. Our colleague, the senator from Oregon, said this, and I quote, "Advice and consent was never envisioned as a check that involved a minority of the Senate being able to block a presidential nomination," end of quote. Well, now that senator is withholding his blue slip for a nominee to the Ninth Circuit. If he didn't believe 41 senators should be able to block a nominee, he surely wouldn't believe that a single senator would have that right. The Democrats seriously now, I think, regret that they abolished the filibuster, as I warned them about at that particular time when they were trying to add a lot of people that weren't needed on the D.C. Circuit Court of Appeals, as an example. Packing the court, in other words. But they expect to use the blue slip courtesy in the place of a veto. I mean that they can't veto it because there's not a filibuster, so then they want to use the blue slip for that purpose. It's very clear from the history of the blue slip, that's not what the blue slip was meant for. On the other hand, some have argued that the blue slip courtesy has no place in modern judicial confirmations. The LA Times recently suggested getting rid of the blue slip, as did the New York Times several years ago. Even our committee's ranking member, Senator Feinstein, once advocated abolishing the blue slip. I disagree that we should abolish the blue slip. The blue slip serves the important purpose of encouraging consultation between the White House and the Senate. Otherwise, the constitutional provision of advise and consent is just consent, but there's opportunity to advise ahead of time. That's what the blue slip helps do. The blue slip serves the important purpose, then, of encouraging consultation between the White House and the Senate. The White House has an obligation to engage in good faith consultation with home state senators for the purpose of advice. I would allow the White House, I won't allow the White House to just steamroll home state senators, but as I've said all along, I won't allow the blue slip process to be abused. Ever since last November, when the press has asked me about the blue slip, I said we're going to honor the blue slip process, but there are always exceptions. So I'm not going to allow senators to prevent a committee hearing for political or ideological reasons. Those are the least reasons to not have a hearing. Using the blue slip for these purposes is not consistent with historical practice. This brings me then to the nomination, one of the two nominations we're having up on November 29th, Justice David Stras of Minnesota. Justice Stras appears to be exceptionally well qualified, graduating first in his class from the University of Kansas Law School. He clerked for both the Ninth Circuit and the Fourth Circuit, and then for Supreme Court Justice Clarence Thomas. After several years in private practice in Minnesota, Justice Stras joined the faculty of the University of Minnesota Law School. He remained there until his appointment to the Minnesota Supreme Court 2010. In 2012, he was elected to a full 6-year term on the court by the 56% of Minnesota voters. Now think about, you're not returning a blue slip when somebody gets 56% of the vote to be returned to the court. Justice Stras was raised by a single mother in Kansas. He's the grandson of a Holocaust survivor. He carries the lessons passed down by his grandparents with him each day. I want to refer to a writing he just submitted to a leading newspaper, writing recently about their survival in Auschwitz and then immigrating to the United States. He recalled that his grandfather had, quote, the uncommon gift of being able to see the light of human generosity in the midst of near total darkness, end of quote. He wrote that his grandparents embraced, quote, a message of optimism intended to ensure that their children and grandchildren were able to lead a life free from the atrocities that they had witnessed, end of quote. Justice Stras has an impeccable reputation in Minnesota legal communities. His former colleagues at the University of Minnesota Law School described him as a person who, quote, engaged in debate respectfully, listening to opposing ideas while backing up his own views with facts and arguments, and who, continuing to quote, wanted our students to be exposed to a wide range of beliefs, end of quote. Another group of colleagues of Justice Stras from his days in private practice described this justice as the type of attorney who, quote, never talked down to people, and there was never any hint that he felt himself superior to anyone, end of quote. Instead, Justice Stras, continuing to quote from this letter, listened to other views and worked to find an approach to legal problems that was both effective and acceptable to everyone on the team, end of quote. They also noted in that letter his dedication to mentoring young lawyers. Despite these accomplishments and accolades, one senator has withheld his blue slip. Evidently, my colleague from Minnesota believes that Justice Stras has not even earned a hearing before the Senate Judiciary Committee. But the reasons given for withholding the blue slip are not consistent with the blue slip's purposes and history. Justice Stras was nominated to the Eighth Circuit on May 8th, more than 6 months ago. After many months, my colleague formally announced that he would not return a blue slip. He cited Justice Stras's, quote, deep conservative judicial philosophy, end of quote, as well as his admiration for Justice Thomas and Justice Scalia. To me, this amounts to an ideological litmus test. Admirers of Justice Thomas and Justice Scalia need not ever apply for being on a circuit court. The Minnesota Star-Tribune editorial board summed it up. They said the senator from Minnesota, quote, rejected Stras for one reason, the justice's conservative views, end of quote from the newspaper. The editorial board of the largest newspaper in Minnesota echoed retired Justice Paul Anderson, quote, while Stras is more conservative than I like, that is not the point. The question is whether Stras is qualified to serve on the Eighth Circuit, and he is, end of quote. My colleague later claimed that he was not adequately consulted by the White House, which would be a legitimate reason for withholding a blue slip, as I hope I've implied several times during my remarks today and before. So I looked into this by reviewing the records of consultation, and thank God the White House keeps pretty good records. It's clear the White House earnestly and repeatedly attempted to work with both home state senators. The White House reached out to my colleague from Minnesota several times between January and May of this year to discuss this 8th Circuit vacancy that the Minnesota supplies the member for. It wasn't until May 2 that my colleague suggested alternatives to Justice Stras. That was more than 3 months after initial contact by the White House. Nevertheless, the White House did what they should under the Constitution, listening to senators. They considered my colleague's 2 suggested nominees. I am satisfied that the White House adequately tried to consult with both home state senators as the Constitution requires under advise and consent. Therefore, I am not going to deny Justice Stras a hearing. I would like to say a brief word about Justice Stras's supposedly rigid conservative views. The Judiciary Committee has received numerous letters attesting to Justice Stras's intellectual honesty and, probably more importantly, open-mindedness. It is clear that he has great respect for the rule of law, and his tenure on the Minnesota Supreme Court demonstrates that, like any good judge, he is able to put aside his personal views and apply the law faithfully. One letter written by a bipartisan group of attorneys from Justice Stras's former firm noted that they, and I quote, never doubted for a minute that he reached his decisions based on his well-considered view of the law and not personal, political, or ideological considerations, end of quote. But then they went on to note, and I quote again, the lawyers whose names appear at the bottom of this letter span the political spectrum, from Democrat to Republican, liberal to conservative. We differ on our personal political views, but we are united in our support of Justice Stras's nomination to the 8th Circuit Court of Appeals, end of quote. Now, there's all kinds of people writing that letter. If you say Democrat to Republican, liberal to conservative, how come a senator is concerned about ideological views when people that know him well seem to think that that's not a consideration because he's going to make a good judge? A group of former colleagues at the University of Minnesota agree. They wrote a letter to the committee stating, and I quote, we are Minnesota law professors with diverse political views ranging from very conservative to very progressive. Some of us have appeared before Justice Stras as advocates, and all of us are familiar with his academic and judicial track record. Now, as I continue to quote, I want to say to everybody, now get this. Continuing to quote, he is no extremist, and he has approached his academic and judicial work without bias or favoritism, end of quote. This support is echoed by his colleagues in my state of Iowa. The committee has received several letters of support from the faculty at the University of Iowa College Law, where Justice Stras teaches as an adjunct professor. Among his supporters are the Dean of the Law School, Gail Agrawal, and Professor Sheldon Kurtz, a self-described, quote unquote, lifelong liberal. Justice Stras is widely respected jurist, and he should have a hearing. and ideological differences should not prevent the committee from moving forward. I'd like to move on to another person that's up November 29th. So I want to address my decision to hold a hearing for Kyle Duncan, a nominee for the Fifth Circuit. He also has not had 2 positive blue slips returned. He is a widely respected appellate lawyer who has litigated over 30 cases in federal and state appellate courts, including the United States Supreme Court. My friend and colleague, Senator Kennedy of Louisiana, has declined to return a positive blue slip. However, Senator Kennedy expressed that while he is undecided on Mr. Duncan's nomination, he does not oppose a hearing for Mr. Duncan. Now, this seems to me this is a very sensible approach. It's a correct distinction that a senator should make when deciding whether to return a blue slip. The blue slip is not meant to signify the senator's ultimate support or opposition to the nominee. It only expresses the senator's view about whether the nominee should have a hearing. Senator Feinstein made this precise distinction in 2003 for Carolyn Kuhl's nomination. I've referred to that nomination earlier in my remarks. Senator Feinstein returned a blue slip that noted that she, quote, reserved judgment, unquote, on Carolyn Kuhl. She also supported holding a hearing for Judge Kuhl. Ultimately, after Judge Kuhl's hearing, Senator Feinstein decided to oppose the confirmation. Eventually, the hearing served a useful purpose, and Senator Feinstein was able to distinguish between allowing a hearing and supporting a nominee. Senator Kennedy has shown that he understands this distinction as well. I look forward to hearing from Justice Stras and Mr. Duncan at the Senate Judiciary Committee hearing on November 29th. I think that all 100 senators ought to look at the advice and consent clause. You have an opportunity to give advice to a president. You have an opportunity then, if that nominee comes up here, to vote for that nominee. Do you want to preserve the advice part of advice and consent? If you do, I would suggest that you look at the blue slip as a useful tool for accomplishing a very important part of the process. And maybe if it's abused, at least not while I'm chairman, you don't have to worry about it going away. But if it's abused, someday it may go away, and then all you're going to have when it's all said and done is consent.